expected the tension to reach such heights in the Supreme Court that day. Justice Sonia Sotomayor's voice cut through the chamber like a knife as she stared directly at former Florida Attorney General Pam Bondi, who stood calmly at the respondent's table. "Ms. Bondi, your argument fundamentally misunderstands decades of established precedent," Justice Sotomayor declared, her tone unmistakably dismissive. "Perhaps you should revisit basic constitutional principles before presenting such theories to this court." The gallery gasped. Legal experts exchanged shocked glances. Such direct criticism from a Supreme Court justice was rare and clearly meant to intimidate. But Pam Bondi didn't flinch. Instead, she opened a leather-bound folder on the podium in front of her, a slight smile crossing her face. "With respect, Justice Sotomayor," Bondi replied, her voice steady and confident, "I believe you'll find that my argument is not only consistent with precedent but directly supported by your own written opinion in Rodriguez versus California." The courtroom fell completely silent. What happened next left even the most seasoned court observers speechless, as Justice Sotomayor's expression transformed from dismissive confidence to visible shock. If you want to see true legal brilliance in action and witness how preparation can overcome intimidation, watch this entire video. Don't forget to like and subscribe for more revealing moments that the mainstream media won't show you. The case before the Supreme Court, Millbrook County versus Federal Environmental Agency, had begun as a local dispute but quickly evolved into one of the most significant federalism cases in decades. At its core was a fundamental question: to what extent could federal agencies impose regulations on states without clear congressional authorization? Pam Bondi hadn't initially been expected to argue the case. With her tenure as Florida's Attorney General behind her, she had been working as a legal consultant when Millbrook County approached her. Their regular counsel had withdrawn due to health issues just weeks before the Supreme Court hearing. "I reviewed their case and saw something everyone else had missed," Bondi would later explain. "This wasn't just about environmental regulations. This was about a constitutional principle that transcended political divisions." Bondi had built her reputation through a unique combination of legal scholarship and practical experience. Before becoming Florida's first female Attorney General, she had served as a prosecutor for nearly 2 decades, handling complex cases that required both detailed legal knowledge and the ability to communicate clearly to juries. During her time as Attorney General, she had argued before the Supreme Court twice, earning respect from colleagues across the political spectrum for her thorough preparation and straightforward approach. What few people knew was that Bondi had spent the last 6 months independently researching the history of federal agency power, initially for a legal textbook she planned to write. This research had given her an unusually deep understanding of the very issues central to the Millbrook case. Meanwhile, Justice Sonia Sotomayor had established herself as one of the court's most formidable members. Appointed in 2009, she had become known for her sharp questioning and detailed opinions. Legal analysts often noted her particular expertise in administrative law cases, and she rarely hesitated to challenge arguments she found lacking, regardless of who presented them. The morning of the hearing, national news programs predicted a straightforward outcome. Most legal experts expected the court to side with the federal agency, citing decades of precedent giving agencies broad regulatory authority. The consensus view was that Millbrook County faced an uphill battle against established legal doctrine. "This case is essentially over before it begins," commented one prominent legal analyst on a morning news show. "The county's position contradicts decades of administrative law. It would take a legal miracle to overcome that weight of precedent." As Bondi prepared in a small conference room near the Supreme Court, she reviewed her notes one final time. Among them was a collection of Justice Sotomayor's own opinions spanning the past decade. Bondi had highlighted specific passages that few had noticed, passages that suggested Sotomayor herself had expressed concerns about unchecked agency power in specific contexts. "They're underestimating her," Bondi told her small legal team. Justice Sotomayor isn't ideologically rigid. She follows principle and precedent, even when it leads to unexpected places. That's exactly why I think we can win her over. No one knew that the hearing was about to become one of the most discussed legal confrontations in recent Supreme Court history. The Supreme Court chamber hummed with anticipation as the justices entered. The grand marble columns and rich mahogany benches seemed to amplify the tension. Reporters leaned forward in the press section, their pens poised. Law students who had lined up since 4 a.m. to secure seats whispered excitedly to one another. Chief Justice Roberts called the case, and the Solicitor General rose to defend the federal agency's position. His argument was polished and confident, emphasizing the long history of deference courts had shown to agency expertise. With practiced ease, he fielded questions from the conservative justices, his responses reinforcing the narrative that federal agencies needed flexibility to address complex modern problems. The statute provides ample authority for the agency's actions, he concluded with an air of certainty. Any other reading would cripple necessary environmental protections nationwide. When Pam Bondi's turn came, she approached the podium with calm determination. Unlike many advocates who began with flowery rhetoric, Bondi opened with a clear statement of principle. Her blue suit contrasted with the dark wood of the courtroom, and she arranged her notes methodically before looking up at the justices. "Mr. Chief Justice, and may it please the court," she began, her voice steady and resonant. "This case asks whether federal agencies can fundamentally reshape the relationship between states and the federal government without clear congressional authorization. Our Constitution requires the answer to be no." Several regular court observers exchanged glances. Bondi's framing immediately shifted the case from routine administrative law to constitutional principle. It was a bold move that risked alienating justices who preferred incremental approaches. Justice Thomas asked the first question, his deep voice breaking the momentary silence. "Ms. Bondi, how do you respond to the government's assertion that environmental problems don't respect state boundaries and thus require federal solutions?" Justice Thomas, interstate effects certainly justify federal involvement, but not unlimited federal control. Our Constitution's design still requires that significant shifts in federal-state balance be clearly authorized by Congress, not created through agency interpretation. Justice Alito followed with a question about statutory interpretation, and Bondi smoothly walked through the relevant provisions, pointing out specific language limitations. Both seemed receptive to Bondi's framing of the issue. But legal observers were waiting for Justice Sotomayor, who had established herself as a strong defender of agency authority in previous cases. During the Solicitor General's argument, she had nodded approvingly several times and asked questions that highlighted the practical benefits of the agency's approach. When Sotomayor leaned forward, the courtroom tensed. A former prosecutor herself, Sotomayor was known for penetrating questions that could unravel an advocate's entire argument. Court watchers called it the Sotomayor stress test. "Ms. Bondi," Sotomayor began, her tone immediately challenging, "you speak of constitutional principles, but you're asking us to overturn 4 decades of settled law on agency deference. Stability in law matters. How do you reconcile your position with the court's consistent recognition of agency expertise in complex regulatory matters?" The question cut to the heart of modern administrative law. Several law professors in attendance leaned forward, eager to hear Bondi's response to this fundamental challenge. Bondi nodded respectfully. "Justice Sotomayor, we're not asking the court to abandon deference entirely, but rather to recognize its constitutional limits. When agencies claim authority that fundamentally alters the federal-state balance without clear congressional intent, they exceed those limits." Sotomayor wasn't satisfied. "That's a fine theoretical statement, but in practice, your approach would cripple essential regulatory functions. Courts aren't equipped to second-guess technical determinations made by subject matter experts. There's a critical difference, Bondi countered, between deferring to expertise on technical matters and allowing agencies to fundamentally restructure constitutional relationships. The former is appropriate. The latter violates separation of powers. Sotomayor's expression darkened. Ms. Bondi, courts have long recognized that effective administration of complex statutory schemes requires agency flexibility. Your approach would return us to the pre-New Deal era where courts micromanaged economic regulations. With respect, Justice Sotomayor, our position is much more nuanced, Bondi replied. We fully accept agency expertise in technical domains. We simply maintain that when agency action crosses from technical implementation to restructuring constitutional relationships, additional safeguards must apply. The exchange continued, with Sotomayor pressing harder with each question. Other justices occasionally interjected, but it was clear that Sotomayor had zeroed in on what she perceived as the fundamental weakness in Bondi's position. The justice's questions became increasingly pointed, and her tone grew sharper. A veteran court reporter from the Washington Post would later describe the exchange as one of the most intense attorney-justice confrontations in recent Supreme Court history. Another observer noted that Sotomayor seemed determined to expose what she initially viewed as a fundamental flaw in Bondi's constitutional theory. Ms. Bondi, Sotomayor continued, her voice growing more dismissive, your argument fundamentally misunderstands decades of established precedent. Perhaps you should revisit basic constitutional principles before presenting such theories to this court. The comment crossed the typical boundaries of judicial questioning. Several reporters later described it as an attempt to publicly lecture Bondi. Some observers in the gallery visibly winced at the harsh tone. Justice Barrett raised her eyebrows slightly, and Chief Justice Roberts shifted in his seat, possibly preparing to intervene if the exchange became too personal. This was the moment captured in the opening of our story, where many advocates might have faltered or become defensive. Lesser attorneys had crumbled under far milder criticism. The courtroom seemed to hold its collective breath. Instead, Bondi calmly opened a leather-bound folder on the podium, her composure unbroken. Those seated closest to the bench noticed something remarkable. Rather than appearing flustered, Bondi's eyes reflected what could only be described as prepared confidence. With respect, Justice Sotomayor, Bondi replied, her voice steady and clear, I believe you'll find that my argument is not only consistent with precedent but directly supported by your own written opinion in Rodriguez v. California. A subtle shift occurred in the courtroom. Justice Sotomayor's expression changed almost imperceptibly. First surprise, then the focused attention of a judge confronted with her own reasoning. Even the court sketch artists paused, sensing the pivotal moment unfolding before them. In Rodriguez, Bondi continued, turning to a marked page, you wrote, and I quote, when agency action fundamentally alters the balance of state and federal power without clear congressional authorization, courts must examine such claims with particular skepticism. You further noted that administrative convenience cannot justify the erosion of constitutional boundaries. Several justices glanced toward Sotomayor, whose intense focus on Bondi had taken on a different quality. The justice reached for her own materials, clearly searching for the opinion Bondi had cited. Bondi wasn't finished. Additionally, in your concurrence in Thompson v. Department of Interior just 2 terms ago, you expressed concern about the gradual expansion of agency authority beyond what Congress could have envisioned when creating the agency. That concurrence specifically cautioned against interpretations that would transform cooperative federalism into federal commandeering through regulatory reinterpretation. Justice Kavanaugh leaned over and whispered something to Justice Barrett. In the press section, reporters were frantically flipping through reference materials, trying to verify Bondi's citations. Sotomayor leaned back slightly, studying Bondi with new intensity. Legal observers familiar with the justice noted a subtle shift in her demeanor, from dismissive to evaluative. She was reassessing not just Bondi's argument but Bondi herself. "These principles," Bondi continued, her rhythm unbroken, "are precisely what we're asking the court to apply here. The agency's interpretation doesn't just regulate environmental standards. It effectively commandeers state resource allocation decisions in a way that transforms the state into a subordinate of the federal agency rather than a co-equal sovereign in our federal system." She turned to another tabbed page. "The agency's directive requires states to restructure their internal governmental processes, reallocate budget priorities established by state legislatures, and submit to federal approval on matters historically governed by state constitutions. This goes far beyond technical implementation of environmental standards." Justice Kagan, perhaps sensing her colleague's surprise, jumped in with a question about practical implications. "Ms. Bondi, if we accept your framework, what happens to the environmental protections the agency is trying to implement? Are you suggesting states should be free to ignore pollution that crosses state lines?" The question gave Sotomayor a moment to review her notes. Court watchers observed her flipping back to what appeared to be copies of her own prior opinions, a pen in hand. "Not at all, Justice Kagan," Bondi responded. "Interstate pollution absolutely justifies federal action. Our objection isn't to the environmental goal, but to the specific mechanism the agency has chosen. Congress has many constitutional tools to address interstate environmental challenges: direct regulation of pollutants, conditional spending programs, or interstate compacts. What Congress cannot do, and therefore what agencies cannot do through interpretation, is eliminate the constitutional division of authority between federal and state governments." The dynamic had shifted. When Sotomayor next spoke, her tone had changed. Gone was the dismissive edge. In its place was the sharp, probing analysis for which she was respected, but now directed at testing the boundaries and implications of Bondi's argument rather than dismissing it outright. "Ms. Bondi, even accepting your characterization of my opinions in those cases, how do you distinguish this situation from Western States Regulatory Commission v. EPA, where we upheld similar agency action? This wasn't dismissal. It was engagement." Sotomayor was now treating Bondi's argument as worthy of serious consideration. Several court observers later identified this moment as the pivotal turning point in the hearing. Bondi appeared to have anticipated this exact question. Without hesitation, she replied, "The critical difference, Justice Sotomayor, is congressional intent. In Western states, the enabling statute specifically authorized the EPA to establish coordinated implementation frameworks with states. The court found that language sufficient to justify the agency's actions." She turned to a specific page in her brief, the movement precise and practiced. In contrast, the statutory language here contains no such authorization. Section 213(b) merely allows the agency to consult with states on implementation timelines. That language cannot reasonably be stretched to authorize the comprehensive state planning requirements the agency now demands. Bondi held up a document. "If I may direct the court's attention to Joint Appendix page 428, which contains the full text of Section 213. The contrast with the Western States statute could not be clearer." Justice Gorsuch nodded visibly. Even Justice Breyer, typically supportive of agency authority, appeared to be considering Bondi's distinction carefully, making notes on his legal pad. The questioning intensified, but in a fundamentally different way. Rather than seeking to undermine Bondi's position, the justices, including Sotomayor, were now exploring its implications, limitations, and potential applications beyond this specific case. What about situations where states have demonstrated an unwillingness to address serious environmental threats? Sotomayor asked. Doesn't that strengthen the case for federal intervention? State resistance might justify congressional action to expand federal authority through proper legislation, Bondi acknowledged. But it cannot justify agencies rewriting statutory authority themselves. The proper response to inadequate legislation is new legislation, not administrative expansion beyond what Congress authorized. Justice Barrett joined the exchange. Ms. Bondi, your argument seems to suggest a special clear statement rule for federalism concerns. How would courts determine when an agency action triggers this higher standard? Justice Barrett, we're not proposing a novel standard, Bondi explained. This court has long recognized that federalism concerns require heightened clarity, as in Gregory v. Ashcroft and more recently in NFIB v. Sebelius. We're simply applying that established principle to agency interpretation. The questioning continued for another 20 minutes, covering historical precedents, practical implications, and potential limiting principles. What had begun as a seemingly hostile examination had transformed into a substantive legal dialogue. Sotomayor pressed Bondi on several more points, but each time, Bondi responded with specific citations to precedent, often Sotomayor's own words, that supported her position. A constitutional law professor who witnessed the argument later told the New York Times, "I've observed hundreds of Supreme Court arguments, and this was remarkable." Bondi didn't just survive Sotomayor's questioning. She turned it into a sophisticated dialogue that actually strengthened her position. You could practically see Sotomayor reassessing the case in real time. Justice Alito raised a pragmatic concern. Your approach would require courts to make difficult determinations about when agency actions sufficiently impact federalism to trigger heightened scrutiny. How do we draw that line consistently? Justice Alito, courts already make similar determinations in other contexts, Bondi replied. When agencies claim to discover sweeping authority in ambiguous statutory provisions, this court has required clear congressional authorization, as in Utility Air Regulatory Group and West Virginia v. EPA. We're suggesting a similar approach when agency interpretations significantly impact the federal-state balance. As Bondi's allotted time neared its end, Chief Justice Roberts asked what many considered the most critical question. Ms. Bondi, if we accept your position, what standard should courts apply when reviewing agency interpretations that significantly impact federalism concerns? The courtroom stilled. This was the moment that could define not just this case, but potentially reshape administrative law for years to come. Bondi's response demonstrated why she had earned her reputation as a precise legal thinker. Mr. Chief Justice, we propose a straightforward principle grounded in this court's existing jurisprudence. When an agency interpretation would fundamentally alter the federal-state balance, courts should require clear congressional authorization for such a shift. This doesn't eliminate deference, but ensures that major decisions affecting our constitutional structure remain where the Constitution places them, with the people's elected representatives in Congress. She continued, this approach respects agency expertise while safeguarding constitutional structure. It acknowledges that while agencies may have technical expertise, Congress has democratic legitimacy. When those values conflict in ways that affect our constitutional design, democratic legitimacy must prevail. As Bondi returned to her seat, legal observers noted something remarkable. Justice Sotomayor was reviewing Bondi's brief with focused attention, flipping between specific pages cited during the argument. The justice who had begun by attempting to dismiss Bondi was now carefully studying her legal reasoning. A law clerk later reported overhearing Sotomayor murmur to Justice Kagan, "She's actually got a point about Rodriguez. I hadn't considered the implications in this context." Following a brief recess, the court reconvened for the Solicitor General's rebuttal. The atmosphere had changed perceptibly. Law clerks whispered among themselves. Reporters who had expected a routine agency deference case were now frantically researching the precedents Bondi had cited. The Solicitor General, a distinguished advocate with dozens of Supreme Court arguments to his credit, approached the podium with renewed determination. Typically a time for reinforcing the government's strongest points, the rebuttal instead became a defensive effort as multiple justices, including, surprisingly, Sotomayor, pressed him on issues raised by Bondi. "General," Sotomayor began, causing several court observers to sit up straighter, "Ms. Bondi cited my opinion in Rodriguez regarding clear congressional authorization for agency actions that significantly alter federal-state relationships. How do you reconcile the agency's position with that principle?" The Solicitor General appeared momentarily thrown by having to address Sotomayor's own precedent being used against the government's position. He adjusted his glasses, buying a few seconds to collect his thoughts. "Justice Sotomayor, Rodriguez addressed a distinct context involving criminal justice matters traditionally handled by states," he replied, his usual fluidity slightly compromised. "Environmental regulation has long been recognized as an area of concurrent federal authority. The federalism concerns in Rodriguez simply don't apply with the same force here." Sotomayor leaned forward, her expression intense. "But the principle I articulated wasn't limited to criminal matters, was it? It addressed the constitutional structure more broadly." Several observers exchanged glances. Sotomayor appeared to be seriously considering Bondi's argument that her own judicial philosophy, consistently applied, should lead to ruling against the agency. "I would argue the principle should be applied contextually," the Solicitor General responded, visibly less confident than earlier. "Different constitutional values are implicated in different regulatory domains." Justice Kagan, perhaps attempting to help the government's case, redirected the discussion to practical concerns about environmental protection. "General, what would be the practical effect of requiring clear statement rules for federalism impacts? Wouldn't that potentially undermine important environmental objectives?" "Exactly, Justice Kagan," the Solicitor General replied, grateful for the lifeline. "Congress designs these regulatory schemes with flexibility in mind, recognizing that agencies need room to adapt to changing circumstances and emerging problems." But Sotomayor returned to the federalism question moments later, surprising those who expected her to remain firmly in the government's corner. "General," she continued, setting aside Rodriguez, "how do you respond to Ms. Bondi's textual argument? The statute authorizes consultation on implementation timelines. Does that language truly authorize the comprehensive state planning requirements imposed by the agency?" The Solicitor General's response involved a complex discussion of implied authorities and administrative necessity, arguments that seemed increasingly strained as Sotomayor continued to press for specific statutory language. "When Congress creates a regulatory scheme with broad objectives," he argued, "it implicitly authorizes the implementing agency to take measures reasonably necessary to achieve those objectives." Justice Barrett jumped in. "But there's a difference between interpreting ambiguity and discovering expansive authority in relatively narrow language, isn't there? Where do we draw that line?" The Solicitor General was now facing challenges from multiple directions. "The line, Justice Barrett, must account for practical governance needs. Congress cannot anticipate every implementation detail when drafting legislation." Justice Gorsuch, known for his skepticism of expansive agency authority, pressed further. "The question isn't whether Congress can anticipate every detail, but whether it must clearly authorize significant shifts in our constitutional structure. Isn't that Ms. Bondi's core argument?" As the rebuttal concluded, court observers witnessed something extraordinary. Justice Sotomayor, who had begun the session apparently firmly in the government's corner, was now openly questioning the legal foundation of the agency's position. The justice who had initially seemed determined to dismantle Bondi's argument was instead engaging with its central premises. A prominent legal commentator who witnessed the argument later described it as watching judicial open-mindedness in real time, a justice confronting a perspective that challenged her initial position and genuinely wrestling with its implications. During the justice's private conference immediately following oral arguments, a discussion later described by insider sources to legal journalists. Sotomayor reportedly made a remarkable statement. "I came into this case believing the precedents clearly favored the government," she allegedly told her colleagues. "But Ms. Bondi's argument has forced me to reconsider. If we're serious about federalism as a constitutional principle, we need to be consistent in its application." According to these sources, Sotomayor went on to say, "When I wrote Rodriguez, I meant what I said about requiring clear authorization for actions that reshape federal-state relationships. If I meant it then, I should mean it now, even if it leads to a result I might not prefer on policy grounds." Justice Breyer reportedly expressed concern about practical implications for environmental regulation, while Justice Thomas emphasized the importance of constitutional structure. Chief Justice Roberts suggested that a carefully crafted opinion could address both federalism concerns and practical regulatory needs. The discussion was unusually extended, with multiple justices commenting on Bondi's effective advocacy and use of precedent. What had seemed like a straightforward case now appeared to be evolving into a significant constitutional statement about agency power and federalism. In the days following oral argument, legal blogs and news outlets were filled with speculation about the case. Many predicted a narrow ruling that would avoid major doctrinal changes. Others suggested the case might become a landmark in administrative law jurisprudence. 3 weeks later, when the court issued its decision, legal experts were stunned. In a 6-3 ruling, the court sided with Millbrook County, with Justice Sotomayor joining the majority. Even more surprisingly, Sotomayor authored a concurring opinion that explicitly developed the principles Bondi had advocated. While courts rightly defer to agency expertise in technical matters, Sotomayor wrote, "We cannot abdicate our responsibility to ensure that agencies act within the bounds of their statutory authority. When agency action fundamentally alters the federal-state balance, a core constitutional concern, we must require clear evidence that Congress intended such a result." The opinion continued, "Upon careful review of the statutory text and context, I cannot find the clear congressional authorization necessary to justify the agency's intrusion into traditional state functions. As this court has repeatedly recognized, administrative convenience cannot justify the erosion of constitutional boundaries." Sotomayor directly addressed her own evolution on the issue. In Rodriguez v. California, this court articulated a principle that transcends specific regulatory contexts, that significant alterations to our federal structure require clear congressional authorization. Consistency in constitutional interpretation demands that we apply this principle, even when it might lead to results that limit regulatory authority we might otherwise uphold. Legal commentators immediately noted how closely Sotomayor's opinion tracked the arguments Bondi had presented. Several pointed out that Sotomayor had essentially expanded on her own previous federalism concerns in a way that few had anticipated. A former Sotomayor clerk, speaking anonymously to a legal publication, expressed admiration for the justice's intellectual honesty. "What makes Justice Sotomayor extraordinary isn't that she never changes her mind, but that she's willing to follow legal principles to their logical conclusion, even when that means reconsidering her initial position. That's what genuine judicial integrity looks like." The majority opinion, written by Chief Justice Roberts, established what commentators quickly dubbed the Millbrook Principle, requiring clear congressional authorization for agency actions that significantly impact the federal-state balance. While careful to emphasize that the holding did not undermine all agency deference, the opinion nonetheless represented a meaningful constraint on administrative authority. In a moment captured by courtroom artists and later widely shared, Sotomayor had approached Bondi after the decision announcement, extended her hand, and said something that caused both women to smile. While court protocol prevented disclosure of their private conversation, those nearby reported that the exchange appeared genuinely warm and respectful. CNN legal analyst Joan Biskupic later reported that Sotomayor had told Bondi, "That was masterful advocacy. You made me think differently about my own precedent." A prominent legal blog summarized the significance. What we witnessed was extraordinary. A justice with the intellectual honesty to reconsider her position when presented with a compelling legal argument, even when that argument used her own words to challenge her initial inclination. It's a testament to both Sotomayor's judicial integrity and Bondi's exceptional advocacy. Professor Akhil Reed Amar of Yale Law School observed, "This case will be taught in law schools for generations, not just for its doctrinal significance, but as a case study in effective advocacy." Bondi didn't just win an argument. She changed a justice's mind by appealing to that justice's own stated principles. The Millbrook decision sent immediate shockwaves through administrative law circles. Law professors scrambled to update their course materials, and federal agencies began internal reviews of regulations that might be vulnerable under the new standard. The media reaction split, predictably, along ideological lines. Conservative outlets celebrated a victory for federalism and constitutional limits, while progressive publications worried about potential weakening of essential environmental protections. But even critics acknowledged the intellectual seriousness of the court's analysis, particularly Sotomayor's concurrence. What nobody could deny was Pam Bondi's remarkable legal achievement. A case that most experts had considered hopeless had resulted in a significant constitutional ruling, largely because of her thorough preparation and precise argumentation. 2 weeks after the decision, Bondi gave her first interview about the case to a legal podcast. The host asked about the confrontational moment with Justice Sotomayor that had now become famous in legal circles. "I never viewed it as confrontation," Bondi explained. "The Supreme Court is supposed to be challenging. The justices ask difficult questions because they're testing the limits and implications of our arguments. That's their job." When pressed about how she had remained so composed under pressure, Bondi revealed the extensive preparation behind her confident performance. "I spent months studying Justice Sotomayor's opinions, not just the majority opinions everyone knows, but her concurrences and dissents where she often explores nuanced legal principles. I found a consistent thread of concern about constitutional structure and separation of powers that doesn't fit neatly into ideological categories." Bondi continued, "What I admire about Justice Sotomayor is her intellectual consistency. When she establishes a principle in one context, she's willing to apply it even when it might lead to results that don't align with her policy preferences. That's what genuine judicial integrity looks like." The impact of the case extended far beyond environmental regulation. Law schools began offering seminars specifically analyzing the Millbrook decision and its implications for administrative law. Bar associations invited Bondi to speak about effective advocacy before the Supreme Court. Perhaps most significantly, a new approach to agency deference began taking shape in lower courts. Judges across the ideological spectrum started applying what some called the Millbrook-Sotomayor framework, requiring agencies to identify specific statutory authorization for actions that significantly impacted federalism concerns. 6 months after the decision, Justice Sotomayor gave a speech at a judicial conference where she addressed the case directly, though without naming Bondi specifically. "The beauty of our legal system," she said, "is that it forces us to constantly test our assumptions against principles. Sometimes an advocate helps us see connections between cases or concepts that we hadn't fully explored. Those moments are valuable, even, perhaps especially, when they challenge our initial inclinations." She added, "When we speak of the court as a deliberative body, this is precisely what we mean. Not that we always reach consensus, but that we remain open to persuasion through reasoned legal argument." For Bondi, the case represented more than a professional triumph. It demonstrated something essential about the American legal system, that well-researched arguments grounded in constitutional principles could prevail regardless of political alignment or initial judicial skepticism. "What matters isn't who makes the argument," Bondi explained in a commencement address at her alma mater a year later. "What matters is whether the argument is faithful to constitutional principles and precedent." When we approach legal advocacy that way, we strengthen not just our case, but our entire system of justice. Legal scholars noted how the case exemplified the ideal of the court as a forum for reasoned deliberation rather than political posturing. The image of Sotomayor, initially dismissive but ultimately persuaded by Bondi's careful reasoning, became a powerful symbol of intellectual integrity in an increasingly polarized legal landscape. Senator James Lankford perhaps best summarized the case's broader significance during a Judiciary Committee hearing. The Millbrook decision reminds us that constitutional principles transcend political divisions. When we return to first principles, like federalism, separation of powers, and clear congressional authorization, we often find common ground that isn't visible in our political debates. For ordinary Americans, the case represented something simpler but equally important: proof that the system could still work as designed, that careful preparation could overcome intimidation, and that reasoned argument could still persuade even across ideological lines. As one constitutional law professor told his students, "Study the Millbrook case not just for its legal holding, but for its process. It shows what's possible when advocates prepare thoroughly, when judges remain open to persuasion, and when everyone involved prioritizes constitutional principles over predetermined outcomes." Today, as federal and state governments continue navigating their complex relationship, the principles established in the Millbrook case provide an essential framework, a testament to what happened when a prepared advocate met a principled jurist and both put the Constitution first. If this video helped you understand how our legal system is supposed to work, don't forget to like, share, and subscribe. We bring you the stories that matter, the confrontations that reveal character, and the moments of integrity that restore faith in our institutions. Hit that notification bell so you never miss our content about what's really happening in America's courtrooms today.
Before you leave this video, pause. Not just physically, pause within. Take a breath. Let these words settle into your heart. You came here for a reason. Maybe you're tired, maybe you're searching, maybe you're just trying to feel seen. And let me tell you, you are. You matter. Your growth, your healing, your dreams, they matter. You don't need to have everything figured out. You don't need to be perfect. You just need the courage to keep going. One step. One choice. One day at a time. Most people stop when life gets hard. But you're not most people. You're still here. Still growing. Still rising. And that is strength. You've survived things that tried to break you, and you're still standing. That makes you powerful. Your past does not define you. Your pain is not your identity. Your future is still unwritten, and it's waiting for the version of you who refuses to quit. Progress is quiet. It happens in the small choices. Choosing discipline over distraction, healing over hiding, showing up even when it's hard. That's how transformation happens. And if you're doubting yourself right now, hear this: you are enough. Not one day, today. The world doesn't need a perfect version of you. It needs the real, rising, resilient you. So make the choice to keep moving. Take that one step. Read the book. Have the conversation. Believe again. Because small steps add up, and one day, you'll look back and realize, you've become the person you once dreamed of. Like this video if you're choosing yourself today. Comment your biggest takeaway. Subscribe if you're serious about your growth. Share this with someone who needs it. This journey won't be easy, but it will be worth it. You are not alone. You are capable. You are powerful. Let this moment be your turning point. Until next time. Stay grounded. Stay motivated. Stay unstoppable.